Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors, and I want to welcome you all to our 2024 Legislative Wrap-Up. Today, we have with us our Director of Advocacy and Public Policy, Lisa May, and our Grassroots and Policy Advocate, Krista McGee. Lisa and Krista are going to dive into the 2024 session updates, issues, policy changes, and overall wins. We do encourage your questions, and we look forward to answering them as we go. Please post questions in the Q&A box below at the bottom of your Zoom screen. And with that, I will turn it over to Lisa.
Kelly, thank you as always. And thanks to all of you Maryland Realtors who are joining us today. It's a gorgeous day outside. So the fact that you are taking the time to be here is especially impressive. We had another really busy General Assembly session this year. There were 2,600 bills that were introduced. That goes up to about 3,500 total if you include all of the budget amendments and legislative bond initiatives that come in on top of that. And we here at Maryland Realtors, and thanks to our state legislative committee, we reviewed about 235 of those as having some impact on our industry. So really very, very busy for a 90-day session. What we want to do today is take you through some of the highlights. As Kelly mentioned, that includes bills that passed, but also some things that didn't, and the role that Maryland Realtors played in advocating on your behalf. So with that, I am going to share my screen so that you can follow along with our presentation here. And let me put that over into slideshow mode. All right, and to kick it off, Krista is going to take us through some bills that we hope are very familiar to you, which are our Realtor priority initiatives for this session. So, Krista, the floor is yours.
Hello, everybody. I'm Krista McGee, Grassroots and Policy Advocate with Maryland Realtors. I want to echo Lisa's appreciation for you all spending your time with us here today. So let me get right into it. With Senate Bill 542, brokerage agreements, in terms of requiring brokerage agreements, Maryland already was ahead of the curve in comparison to most states. Senate Bill 542 enhances what was already in the books, and it will provide better clarity for consumers. So what has changed, or more accurately has been fine-tuned? Well, first of all, the brokerage agreement must have a definite termination date. The amount of compensation that is being paid to the broker must be specified in the agreement in actual amounts. Now, this can be a dollar amount, a fixed percentage, or a combination of the two. You also have to specify what happens if the amounts that you have agreed to in compensation and what is being offered by the listing broker should differ, and who will pay for what in those types of scenarios. Now, if all this sounds familiar, you are not mistaken. So this was also a part of the proposed settlement agreement with NAR. But additionally, this legislation covers all real estate licensees in Maryland and not just realtors who are subject to the settlement. You would think that we had a crystal ball with this bill and that we worked on it in 2023 and it was introduced in January, even before we knew there was going to be a settlement. So with that, I'm going to move into continuing education, Senate Bill 564. So I'm going to give you a little bit of background on this. Last summer, the Real Estate Commission had made some changes to the continuing education reporting process that created some issues for our CE providers and have impacted our members as well. Previously, this process would work in that licensees would take CE classes from a provider, and that provider would report the credits to the commission. Now, what you may not know is that the providers used to have 14 days to complete the reporting process. And one of the reasons for that is because the CE system on the MREC database requires that each attendee in each class be entered manually one by one. And it also meant that licensees who had taken CE classes at the last minute prior to their expiration might not have their credits showing when it was time for their renewal. which at that time really wasn't a problem because previously the Real Estate Commission allowed you to self-certify that your CE was complete and just not yet uploaded into the portal. However, when the Real Estate Commission performed some auditing and of those self-certifications, they found that many of the licensees that had certified they had completed CE, they had actually never taken. And what happened to those individuals? Well, the Real Estate Commission brought complaints against them for falsifying their records, slapped them with a $1,600 fine, and ultimately decided that because of this, they would no longer allow for self-certifications to be done and that you could only renew once your credits are in the system and not before. So where the problem kind of escalated is that they also asked CE providers like your local realtor associations to upload these credits within 3 days and not 14. And this created a real hardship for your education providers who expressed that they will either need to cut back on CE offerings or they're going to have to raise costs on licensees to allow for quicker processing on completing credits. Now, the old process didn't really work very well for the Real Estate Commission, and the new process created its own issues, and it's not also working for everybody. So, because even if the education providers could upload in 3 days, you would still have licensees who have taken classes at the last minute that wouldn't be reflected in the system at the time of their expiration. So, moving forward, and with the changes under this bill, CE will now be required to be completed 30 days before the expiration date for a normal license renewal. Schools will again have 14 days to report CE within the system, which will allow education providers the time they need to ensure that they continue to offer timely CE to members. Licensees then will have roughly 2 weeks remaining to clear up any discrepancies that may exist between what is showing in the portal as their completed CE and what they have taken over the past 23 months. So what would happen if your CE isn't completed within 1 month of your expiration? You would still be able to complete your CE with less than 30 days left before the expiration. However, you would be subject to the reinstatement fee imposed by the Real Estate Commission. To summarize, for most of you and those of you who complete your CE throughout the year, this change really will not affect you. However, even for those who wait until the last minute or if something comes up as life happens, there would still be an advantage to this change in either scenario, as you would still be able to renew your license with the fee. As it is now, if your license is expired because you're unable to renew due to the unreported CE and you have a closing tomorrow, having the option of the fee would be a trade-off that would be much more advantageous than not being able to move forward with your closing. So that brings me to anonymous advertising complaints. Now, advertising violations are frequently reported to us and our local associations by some concerned members. Also, they are faxed, emailed, and mailed anonymously to the Real Estate Commission. And what happens when those anonymous complaints or inquiries are brought to the commission? Currently, nothing. And this is because under current law, Maryland requires that all complaints that are made to the commission be made under oath by the person who is submitting the complaint. Now, several other states allow anonymous complaints, and with the passage of this bill, Maryland will join them, and the Maryland Real Estate Commission will have the ability to investigate complaints that show sufficient evidence of an advertising violation. Now, the last of these on this slide is the Oversight of Branch Offices Bill, Branch Office Managers Bill, HB 709 and Senate Bill 462. Under existing law, a broker is only eligible to supervise one office location, whereas if he or she were to hire an office manager, they would be eligible to supervise multiple offices. Now, this is probably one of the most straightforward bills that we have this session. And what it does is that it simply allows for brokers to be able to supervise at least as many offices as an office manager is currently allowed to.
Thank you, Krista. I got busy typing up an answer in our Q&A. So thank you guys for submitting those questions into our Q&A. We'll answer as many as we can as we go along, but if we don't get to yours, we will save time at the end to answer those. So let's go on to, while our realtor bills were really, really important, let's go on to one of the biggest issues of this session, which is, if I can, there we go, housing. We have heard so much from our members over the past couple of years about the lack of housing options, the lack of housing supply that we have here in Maryland. And one of the biggest questions we had going into this session is, would we actually see any results from this push on housing? And as you can see on this slide, we believe the answer was a pretty big yes. These first two bills, House Bill 538 and House Bill 599, were part of the administration's housing package. So that came from Governor Moore and DHCD Secretary Day. We have actually, because House Bill 538 in particular does so much in the realm of housing, we actually came up with a handout that gets into all of the ins and outs of it. I was hoping it was going to be just one page. That was overly optimistic. It's two, but that's because it really does a lot. House Bill 538 does not allow local governments to ban manufactured or modular housing through their zoning ordinances. And many of those bans come from a time when manufactured or modular housing meant mobile homes or trailer parks, and local governments didn't necessarily want to see those. Well, today, thanks to all of the advances that we have in the industry, manufactured and modular housing is still stick-built housing. It's just built off-site, moved in, and assembled on-site. So as long as it is affixed to a permanent foundation, modular and manufactured housing will be allowed anywhere that single-family housing or on-site built housing is allowed. So that is a big change. One huge change, maybe not this year, but going forward, was getting middle housing defined in state code. And that has been a big push of Maryland Realtors, of our president, Chris Hill, to really talk about missing middle housing, those starter homes that used to exist, walkable neighborhoods, duplexes, triplexes, things that were typically entry points into our housing market for first-time buyers, for working class buyers, or places that seniors could downsize to. By and large, those are not built in a meaningful manner in our housing market today. So by putting this into state law and by encouraging those housing types through this bill, we are hopeful that we can begin to build that type of housing stock back up. The other thing that House Bill 538 does is it creates density bonuses for housing developers who build mixed income housing developments with some dedicated affordable units, but they also get to add on additional market rate units to help offset those costs. It's a very kind of market friendly type of incentive program that they have here in this bill. And those density bonus developments will go in three specific areas. One, on former state-owned and federal military campuses, areas that are within 3/4 of a mile of a rail transit station, or finally, properties that are owned by a nonprofit. That could be a housing nonprofit, that could be a church or a religious institution for co-location of housing. So all of these will go into effect. This is probably an exception to many of the bills that we will present today that go into effect on October 1. This one goes into effect on January 1. So we are really, really looking forward to this, being the first step in addressing what we estimate is 150,000 housing units that we are short here in Maryland. House Bill 599 is the second piece of the governor's bill. That establishes a statewide housing development finance agency which can help us better leverage federal grants that are out there for the development of extremely affordable housing, units that are restricted to those who make, 30, 50, 60% of the median area income. Also, we have, because we weren't done, there are some other bills that were passed as well. House Bill 7, the Housing Innovation Pilot Program, it really is just that. This is a state loan program for developers that are accessing federal loan programs or maybe several different loan programs to develop mixed income housing and new and really cutting edge types of integrated housing where you have some market rate, where you have some dedicated affordable units. This is essentially the carrot to help those localities who want to develop this access funds. And then finally, House Bill 131 requires local jurisdictions, the big ones, the ones that have 150,000 residents or more, to report to the state how much housing they're actually producing, how many permits were applied for, how many they approved, how many they turned down, and why. Also, if they have any sort of expedited permitting system for certain types of developments, say for workforce or affordable housing, to report how many folks took advantage of those. This will give the state much better data moving forward, which is something that we haven't necessarily had so far in this housing debate. There was one housing bill that didn't pass that we supported, and that was an expedited review for affordable housing. That bill would have required localities, if they had an expedited permitting process in place in their counties, they would have to allow affordable housing developments to use that process to get their projects approved. And that is because we know, all of us, that in development, time is money. And as we can shrink those timelines, as we can streamline that process, it brings units to the market faster and more affordably. So those were our housing bills for this session. I'm going to hop on the Q&A and see if I can answer any of those while Krista takes us through our new disclosures. And we'll cue all of the eye rolls from our members. We know that these are tough every year, that these get added onto the contract process. We understand, which is why I gave them to Krista to talk about, really and truly. But Krista, it is yours. And you are muted.
Thank you. Thank you. I hate when that happens. It happens surely way more than I would like it to. So let me get on to condo asbestos disclosures, House Bill 143. So this disclosure will apply to condos only, and it will require condo owners who sell their property to identify whether there has been asbestos in their unit and whether remediation has been made during their tenure. Already, there are some things that we know unit owners have to disclose already, such as health and building code violations within the unit. So this law just adds the presence of asbestos or abatement to that list, so long as either of which occurred during the seller's ownership of the property. Our goal in kind of working with the advocates who are proponents of this is to mitigate the risk of sellers from being sued. So when these advocates had suggested initially to require sellers to identify whether there has been asbestos present in the unit itself or in the entire development, we naturally had some concerns that this would place sellers at risk for being sued based on not disclosing something that they would likely not have any awareness of. So that is why we have it the way it ended up the way it is, and that it only applies to sellers' actual knowledge based on the time in which they owned the unit that they are selling. Getting into contract disclosures, Superfund sites, Senate Bill 125. This bill has been introduced in a previous session. due to environmental and health implications surrounding Fort Detrick and Frederick, which is a Superfund site, and kind of where this issue or awareness of this issue has arisen from. During last year's session and throughout this most recent session, we've had some back and forth dialogue with the advocates surrounding this issue. Did a ton of work on this bill with them to make it more palatable for our members, and came up with a mechanism that we feel reduces the risk to sellers from what the advocates had proposed. We tried to get this to be just a standard buyer notice, but as a result of the negotiations, that was not able to work out the way we'd liked it to. So ultimately, if there is a Superfund site within 1 mile radius of a property, then the new addendum needs to be used. Why 1 mile radius? Well, because this is an increment that could easily be mapped already from the EPA website mapping tool, where you go to this URL and you go to the mapping tool and enter an address of the property within it, and it will literally draw a circle around that radius of the property. And so then if you find that there is a Superfund site within that radius, the seller is required to provide an addendum to the buyer and notify them of the that there is a Superfund site. And after that notice requirement is triggered by the presence of a Superfund site, the buyer would then get 5 days to terminate the contract. Now, wrapping up with assignment of contracts, House Bill 1408, otherwise known as wholesaling. So this bill was not successful in passing, and what it would have done is that it would you would be required as a wholesaler to tell the seller of the property and the eventual buyer that that is what you are doing. And it would have just required a disclosure to be made by wholesalers, where they make the seller aware of the property and the eventual buyer that they are planning on reassigning the contract, as opposed to just purchasing the property outright. Unfortunately, this bill, like I said, did not pass this session. We're thinking likely because it was introduced later on within the session and just ran out of time in the process. But ultimately, we can expect to see it coming back this coming year.
Excellent. Thank you, Krista. Yeah, we are very, very hopeful that we will get that assignment of contracts bill through this next session. It is an issue that we do hear from you all about. All right, now we come to the part that makes our property managers groan. And yes, unfortunately, there was a host of landlord-tenant bills this year, as there are every other year. I'm actually going to go over these in terms of, excuse me, let me go back. There we go. In terms of degree of difficulty. So we'll start with the easy ones, and then we'll get into the very, very complicated ones. This first bill, House Bill 93, there is an existing law, a lease cancellation provision for individuals who have a diagnosed medical condition that prevents them from living in the property. And under that, they are liable for no more than 2 months of rent. This bill would expand that definition of a medical condition to include a mental disorder that has been verified and diagnosed by a Maryland licensed psychologist. Same right of termination, 60 days, based upon that designation by a medical professional. Second bill, House Bill 139. There are existing requirements in landlord-tenant law that requires a landlord to give the tenant notice of water and sewer charges when it is the landlord who is billed for those charges, and the tenant makes those payments to the landlord, not to the utility provider. This bill would essentially expand that to cover other types of utilities like gas and electric services. Again, this is only if the tenant pays those utilities to the landlord, and then other For instance, if there are ratio billing that is occurring in a larger multifamily home, you would still abide by those as well. I'm going to skip ahead a little bit to House Bill 1117, the Tenant Rights and Safety Act, and then we will circle back to the one that we're already getting questions about, House Bill 697. So the Tenant Safety Act, when renting property, a landlord is going to be deemed to warrant that that unit is fit for human habitation. In other words, there are no life, health, or safety threats to the occupants of that unit. If those violations do occur, the tenant can seek recourse within the courts for either rent abatement or payment of rent into the rent escrow. What changes with this bill is that multiple tenants, let's say it's a multifamily property, 5 tenants have the same complaint, that there's no running water, or that the electricity heat is not working. Those tenants before would have needed to file separate actions in the court. Under this, they can join together against one landlord for common complaints and have that be one court process as opposed to, say, 5 or 6. There is also created a rebuttable presumption that the tenant's complaints are true and that the tenant should receive rent escrow or rent abatement. Now, rebuttable means that the landlord can present evidence that refutes that claim against the tenant to a judge, and then the judge kind of takes it from there. But going in, all else being equal, the judge is going to say, if a tenant's bringing this complaint, then I would probably be inclined to grant their request for rent escrow or rent abatement. And if it turns out that the court finds the landlord did make a violation of this warrant of habitability, that there were unsafe conditions for the tenant, the judge can grant attorney's fees and court costs to the tenant or that group of tenants, that the landlord would need to cover those. Now, you may be saying, well, what does the landlord get out of this? Well, there are a few things that were negotiated into this bill. One, tenant has to notify the landlord that these items exist. Hey, there's black mold all in the carpet. There's, no running water, or whatever the complaint may be. Tenant has to give notification to the landlord and grant a reasonable time for the landlord to fix it before they can go to the courts to seek abatement or to seek rent escrow. The landlord can assert as a defense that the tenant or their guests were the ones that actually caused the condition, or that the tenant prevented the landlord from making necessary repairs. That is a defense in court. And then finally, which was kind of a late minute negotiation and a late minute addition from industry activists, if a tenant uses this process in bad faith, makes a frivolous claim against the landlord can seek to recover their court costs and their attorney's fees from the tenant. And that was a big addition to this bill from how it was introduced. All right, now we're going to go to the granddaddy, the one that you've all heard about. Similar to the housing bill, let me say before I dive in, we do have, again, another 2-pager that summarizes all of the provisions of House Bill 697 on our website, ready to go. And of course, and I don't know that Krista necessarily mentioned this, but we're going to put in a really good plug for our new Legal Ledge update class, because we're going to be going through these bills in depth in that new legal legislative update. So here we go. What does House Bill 697 do? First, there is going to be a publication, a pamphlet that the state is going to put together that outlines what rights a tenant has in Maryland under our law. DHCD is going to publish this. They are going to update it. It is going to be included with a lease that you put in front of a tenant. Number one. Number two, currently under state law, security deposits are allowed to go up to 2 months' rent. Under this bill, security deposits will be limited to 1 month's rent, except in very, very, very narrow circumstances. That narrow circumstance is if your tenant is receiving utility assistance and that tenant pays utilities to the landlord and the tenant and landlord agree, then in that very narrow instance, that security deposit could go up to 2 months. But that's it. All right. Otherwise, for probably 99+% of the leases that are out there, security deposit is 1 month. Next thing, eviction filing fees. It has been said over and over again that Maryland's eviction filing fees are among the lowest in the nation, and that is objectively, that is true. And we have still pushed back against that, but it really was getting harder to make the case that our filing fees should not go up when the national average is, about $125. And ours were, 8 or 18 or 28. So under this bill, the eviction filing fees do go up. They are not recoverable unless the court enters a judgment in favor of the landlord, in which case the landlord can take that filing fee from the tenant's security deposit. Now, all of that is a lot for a bill, but there's even more. There's one more thing, and that is the right of first offer and first refusal. This provision, or I guess these provisions, because there are 3 ways that this could happen, comes from a place of tenants who want to become homeowners should have the opportunity to do so and to not be displaced from their rental property before they've been given an opportunity to purchase it. And when we spoke to the administration, we said, we share your goal of making renters into homeowners, but we really need to make some changes to this right of first refusal as you have proposed it and as this bill was introduced. And so the right of first offer is the result of those negotiations. So let's walk through that. When you want to sell as a rental property owner, you're looking to sell that property. One of 3 things can happen. First, you can, before that property goes on the market, you can provide a notice to the tenant that says, tenant, I am looking to sell the property that you currently live in, and this is the sales price and the terms of how I intend to list it for sale to the public. Are you interested in making an offer based upon the terms that I have outlined? The tenant has 30 days to go talk to a lender, to go talk to an agent, to help them develop this offer to the landlord. By 30 days, they need to submit that offer. The landlord has 5 days after that for any counter that they want to make, any counter offer. And then the tenant has 5 days after that to either accept or reject that offer. If no contract agreement is made within that time frame, the tenant's right to purchase are extinguished. And this is important because if you follow this process, if you are proactive, if you are giving your tenant the 60-day notice to vacate, and you do this notice to purchase, this essentially solicitation of an offer at that 60 days, the tenant's rights under this are going to be extinguished by the time you actually offer the property for sale to the public and to a third party. So your sale moves forward just as it normally would. And that was a really important concession for us to get, because as the bill was introduced, anytime you wanted to sell a rental property, you would have to wait until you got an offer from a third party. And then you would say, no, put that on hold. You need to go sit over there for at least 30 or 45 days while this tenant decides if they even want to buy the property. We didn't think that that served anyone well at all. It doesn't serve the tenant well to be under the gun, to have to meet someone else's offer. It doesn't serve that third party buyer well to think that they could walk in and buy a property and then have to wait that long. And it doesn't serve the rental property owner well as all either. So that was where that right of first offer came into play for us. Two other scenarios. One is, let's say you do that advanced offer to the tenant, you guys go back and forth, you can't come to an agreement at all. And the tenant's rights are extinguished. So then you put the property on the market and you accept an offer that is 10% lower than the lowest offer that you and the tenant negotiated. Okay. If that occurs, and we don't think that this will really occur as particularly in this market, but even so, because 10% is a good amount of money. If that occurs, the tenant essentially gets a second bite at the apple. All right. Then they get 30 days to match that new lower offer and to step in place of that buyer. Third scenario is if the landlord receives an unsolicited offer to purchase. They're not planning on listing the property for sale. They're happy just being a landlord, but someone comes to them and says, hey, you know, I've really been looking for rental property. I think yours is great. Would you entertain an offer of X? In that case, you would need to give the tenant a notice. Hey, I have received an offer for this property of X. You have 30 days to match that offer. You can definitely see in scenarios 2 and 3 that you are putting that third party on hold. You are putting that offer on hold. So we want to avoid those if at all possible. We want to use that right of first offer process as much as we possibly can, because it is to everyone's benefit to do so. We will try to catch up on your questions. I see the Q&A going off. I want to make sure that we get through the full presentation. We will circle back and get all of your questions, and we will stay as long as we need to, everyone, okay? Now, the good news is that we did still defeat some really, really bad landlord-tenant legislation. So there is some good news on this topic. We had prohibitions on rent increases if exact procedures were not followed by the landlord. We had bills to extend the eviction process. We had a really crazy bill. You'll see there, House Bill 1295, about having air conditioning, and it needed to be so many degrees, 3 feet above the floor, and all of these different things. And then House Bill 477 is the big one, the one that we've really been fighting the past few years, which is called either just cause or good cause legislation. And that would require a landlord to have to give an approved reason for non-renewing a tenant's lease. And that has been a no-go for us. Because it really flips what a lease is on its head. A lease is a contract, and when both parties have fulfilled the contract, you can't force someone to enter into a new one against their will, which is essentially what this bill would do. We've been very successful in keeping it at bay, but also, you know, one of these years, you know, if we weren't as successful in killing it outright, in getting a lot of amendments on it that weaken it, for instance, making it a local only bill instead of a statewide bill, and matters such as that. So these are, even with the new landlord tenant bills that did pass, these are still some good wins for our industry when it comes to landlord and tenant matters. All right, condo and HOA. I know that this is a very, very frustrating issue for our members. It is frustrating for us as well. And these were a few of the bills that did pass on condo and HOA issues. First, many of you know developments or have heard of developments that are struggling with the state reserve study requirements. This bill would allow local governments, if they choose, it is optional, but local governments could create a repair fund to help associations that have outstanding infrastructure needs within their development. Cannot be used for recreational facilities, but it could be used for things like roads or stormwater infrastructure, for instance, if a condo and HOA development were really struggling in keeping up with those maintenance costs. House Bill 1227, this is a reiteration of a Realtor bill that we've had, I finally passed last year, that states that detached condominiums are not necessarily required to be on their condo association's master policy. They have the option, the development has the option to set up a purely detached condominium development as they would an HOA, where the individual unit owners pay for their own unit insurance inside and out, and the association covers just the common elements. And then finally, Senate Bill 665 lowers the threshold for developments for condominiums to amend their declarations. Currently, that can be as high as 80%. This lowers it down to 2/3 of the vote of the unit owners. Of course, if we're talking about condo and HOA and bills that pass, we're really kind of burying the lead somewhat. You can see by this list that condo and HOA rules and regulations are an area where the General Assembly really is not keeping up with industry practices and is not exerting the oversight of association practices that they should be. These are all bills that we supported. And in fact, the one at the bottom, resale contracts, Senate Bill 898, that was our Realtor bill. Unfortunately, it was the one that did not make it through from our agenda. And that bill went directly at what we hear from you, our members, which is that you are being charged for the resale packet amounts that are above and beyond what is outlined in state law. We hear hundreds of those per year. And when you are in the midst of that transaction, you have a ticking clock and you really have no choice. If you're acting in the best interests of your buyer and your seller, you have no choice but to pay whatever amount they are asking for. And that's not right. And we are going to the General Assembly and telling them that that is not right. That goes against not just state law, but the negotiation and the compromise that Realtors worked out with the Condo Association Institute many years ago. All we are saying to the General Assembly is that the fees that are charged are the fees that are allowed, no more, no less. We will be putting this bill in again. We know how important it is. Even though it's an uphill battle, we will be putting this bill in again. so that hopefully you and your clients can see some relief from this process, which I think, we can all fairly say is broken and needs to be addressed. All right, time is getting a little short, so I do want to point out one important change in the area of fair housing. We are seeing a lot more bills regarding housing discrimination, fair housing, appraisals, things of that nature. And I think that has been trending upward for a few years now. I think we can expect that to continue. But of these, what I really wanted to point out is House Bill 598, Senate Bill 413. Starting October 1, we will have a new protected class in Maryland, and it is active duty military members. That includes the reserves. So active duty military reserves, their spouses, and their dependents in the areas of housing and employment. That is not to be confused with veterans status. Veterans are not included in this new statewide fair housing class. However, they still remain in some of our local counties. So statewide, it is active duty, spouses, dependents in housing and employment. We submitted comments on this bill. Of course, we are in no way in favor of discrimination against the men and women of our military. But we did point out to the General Assembly that many landlords, for instance, offer incentives to active duty military. Maybe they waive the application fee, or they would knock down, a required deposit or something of that nature. They would give favorable treatment to members of the military. We all know that disparate treatment is disparate treatment when it comes to fair housing. You cannot favor or disfavor someone because of their status in or outside of protected class. And so we told the General Assembly, said, listen, we understand why you want to do this. Just understand from our standpoint that it means we're going to have to discontinue these perks and these things that we, that some of our members report giving to members of the military. They came up with an interpretation. Some committee counsel along the way said, no, you can still give them favorable treatment. No. We think that is just a misunderstanding on their counsel's behalf of how fair housing laws work. So understand that is a change that is coming October 1. All right, every year we have bills on the environment. We actually did defeat some bills that we think would have been harmful to the development of new housing or to housing affordability. So electric only building code standards, bye-bye gas fireplaces, bye-bye gas stoves, bye-bye natural gas heat, retrofitting of existing residences for EV parking and charging equipment, the Better Buildings Act, again, net zero buildings, no greenhouse gas emissions, eventually transitioning to an all electric building code. Things that, we have worked on and that kind of come back up every session, but we were successful in defeating those this year. One thing we did want to point out, and a bill that did pass, because we hear from our locals that different septic issues are, if you'll permit me this pun, percolating in our local counties. This bill requires local health departments to report to the state their permit processing times, so that there is essentially one source of information to compare and contrast and give the State Department of the Environment a true picture of what's going on out there. Septic permitting is kind of a bifurcated process where it's, kind of regulated by MDE, but conducted by local health departments. They don't talk to each other. None of their IT systems are integrated or speak to each other. And there are big disparities that we have heard out there in terms of getting septic systems approved and transfer inspections completed. So with this, we are very hopeful that the state will have a better source of data moving forward, and can use that to fix some of the issues that we are seeing out there in the marketplace. All right. Final slide, and we want to end this on a really, really good note. Taxation is an issue that could have gone sideways for the real estate industry very, very easily. Many of you probably saw in the press, there was a big kind of back and forth between House Democrats, the Senate, and the governor about whether we would seek new revenues to address our out-year budget shortfalls that have sort of come as a result of the blueprint for higher education, the Climate Solutions Now Act, and then also our kind of sluggish economic recovery that we're experiencing after COVID. In 2028, at least based upon current projections, based upon current spending levels, we're projected to have about a $3.8 billion, with a B, billion-dollar budget shortfall. House members said we need to address this now, and I think you can see from the bill numbers on here, these proposals came from the House. They were looking to raise revenue now so that the out years were not so bad. The Senate, and to the same extent, to Governor Moore and his administration, said, wait a minute. If we're raising taxes, and we aren't saying we have to yet, we could grow our economy, a lot of different things could happen. We don't know yet. But if we are to raise taxes, we really need to build, the understanding of why. We need to build some support for this. This is not the year that we are looking to raise taxes. And by and large, that's how it ended. But you can see the threats that we have in the General Assembly. You can see why we have to be vigilant in Annapolis every year. 2 transfer tax bills. I think the last couple of sessions we have had at least 2 transfer tax bills to raise the state transfer tax. House Bill 638 would have made the state transfer tax progressive, and any property over $500,000 would have seen a dramatic increase in the transfer tax that would have been charged on those properties. The Fair Share for Maryland Act, that bill addressed what you can't really tell from the title, can you? But in the details of that bill addressed the estate tax exclusions. It addressed capital gains tax rates. It addressed income from pass-through entities, all things that impact real estate. That was a bill that we opposed. And it did not move forward. Any of the provisions of that did not move forward in the final budget bill that was approved. And last, certainly not least, House Bill 1515 was the second iteration of a sales tax on services. Services being, yes, the work that you do, the work that our property managers do, that mortgage lenders and appraisers and title companies, surveyors, home inspectors, all of those folks do during a transaction. But more importantly, at least we thought this was the way to approach it in this session of housing and session of housing supply. Think of all of the services that go into building a home, building the housing that we need, all of the carpenters and architects and plumbers and electricians and all of those folks, and the cost that would add to an already increasingly unaffordable housing market. We had well over 150 advocates from various business organizations come out and testify against this bill, but we were really the only ones that spoke to the broader implications. Not just of, hey, our Realtor licensees are going to be hit by this, but this is going to have a ripple effect on the most important issue that this administration has put forward. And so we were very happy to see that this bill died without a vote in committee. Does it mean that any or all of these are not coming back in the future? No, we fully expect that they will, particularly if our budget deficits remain the way that they are. We are going to be fighting revenue fights again. But for this year and at this juncture, we are very, very proud of these wins, both for you and for your clients, and we hope that you are as well. All right, I see a huge list, of Q&A here. So I'm going to stop sharing, and Krista and I are going to dive in to your questions. So I don't know, Krista, do you have one kind of teed up that you want to start with here?
You want to clarify about Maryland Realtors Forums Committee and handling the additional disclosures and so forth?
Yeah, absolutely. Our forms committee obviously has been very, very busy already this year, given the settlement and all of the changes that need to take place with that. We have even added even more to their plate with these new disclosures, also the changes that are going to have to come to our lease agreements, you know, under the landlord tenant bills that passed. So yes, Taylor and our forms committee are going to be very hard at work this summer, and you should see those very soon. Let me see here. Oh, I have a very good question about the Renters' Rights and Stabilization Act and how it relates to the city of Baltimore. This is a very interesting provision that was in that bill. The right of first refusal and exclusive negotiation period, those override any local program that existed before or after this bill. And that was, that usually doesn't happen. Let's just say that. Usually it's, okay, anything established after the effective date on the bill needs to comply. This one actually is retroactive. So, so yes, this does override that Baltimore bill. All right, Krista, here's one, the benefits of the CE bill. Since you discussed that one, can you maybe take a stab at that as to why we needed to seek this change?
Yes, because the hardships that were going to be imposed not only on members in terms of not being able to renew due to not going in and be able to take your CE at the last minute when it does happen, and be rest assured that your credits will be uploaded in time, that would prevent a lapse in your licensure. So there's the benefit on that end. And, you know, the benefit also of to the schools and the providers, all education providers, is the ability to continue to be able to offer these classes to you, members and licensees, without having to increase costs or reduce the amount of offerings. This decision had really put the schools in a hard place. And, you know, it's very, can't explain how difficult the process is of having to go through and identify and like type in each line by line all the licensees who have taken the class, but it's kind of very involved. I think that following our conference, we had several people just doing just that for days. So that's kind of to get a little background information as to kind of what precipitated all of this.
Right, thank you. And we had a couple of questions about what a Superfund site is. And that is a site that is designated by the EPA. And it is, in this instance, a National Priorities List Superfund site, or NPL. And that is a site where there has been documented, you know, contamination of groundwater, or you know, where hazardous chemicals were being used. The site that really kind of precipitated this was Fort Detrick in Frederick County. They have had, groundwater infiltration. There's some evidence that perhaps there was like a cancer cluster among individuals who grew up and lived on the land right around Fort Detrick. So there are 26 of these sites within Maryland. A lot of them are military installations. I know that, Andrews Air Force Base was one, in part because of, some spots that have like jet fuel or, things like that, that could be considered environmentally hazardous. Could be. And so, that is what precipitated and what kind of drove this bill and this requirement was the advocates did not want people living there without knowing or being comfortable with whatever risks, if any, those sites present to them. All right, let's see here. Have a couple on I believe, let's see, our House Bill 139 for giving notice. Let's see here. Let's see. Oh, asbestos disclosures. So obviously, yes, if you have like actual knowledge of there being that's existing. If you know of a latent defect, then that needs to be disclosed. Where this really comes in, I think, for the unit owner, and Krista, you can correct me if I'm wrong here, is even if remediation has taken place, technically you would not, before this bill, need to say anything about it because it had been remediated. In this instance, you do. And that's why we limited it just to the term of that owner's tenancy or that, their time within that unit, because they could not be expected to go back and know whether any owner at any point in time had ever, done anything about asbestos that is or is not within the unit, because it was never disclosed to them. Do you have anything to add to that, Krista?
No, it's kind of what I was thinking, but.
Great. Let's see here. I have a question about considerations for small landlords. We did have some consideration. I mean, of course, as Maryland Realtors, we are always talking about small landlords and the differences between mom and pop landlords and the big corporate entities and the big apartment complexes. They are not the same. And we have always tried to seek an exemption from bills when and where possible. Now, when it comes to, for instance, the governor's housing, the governor's rental bill and the right of first refusal, this only applies to 1, 2, or 3 unit properties. Why is that? Because a tenant is not going to go buy, particularly if they're renting 1 unit, they're never going to go buy, a 10-unit apartment building or a 20-unit apartment building or anything like that. It's just not going to happen. In that instance, all it is going to do is hold up the process and create difficulties for those property owners. Under this bill, they thought, maybe a tenant has the ability to buy a single family home. Maybe they have the ability to buy, maybe their parents help them out, or maybe, 2 siblings are going to go in together on a duplex and each occupy one side. That might happen. We still think it's really rare. We still think it's going to be very rare that a tenant actually successfully exercises this right. They're renting for a reason. Maybe it's because they don't have the income. Maybe it's because their jobs or, their time in the area is subject to change. Maybe they're only going to be here a short amount of time, and that's why they're renting. Maybe they don't want the upkeep of an ownership unit. They want the landlord to come and fix things and to take care of the yard and to do those other things. And finally, maybe the tenant, after living there, knows every single thing that's wrong with that house and says, nope, I know how often I have to call the plumber to fix the bathroom. I don't want that on my plate. So really the options for tenants to exercise this, we think is very, very limited. And we do think that landlords are ultimately going to be able to move forward with the sale of their property as they would have under normal circumstances. So I hope that helps. I hope that does give some background. On the just cause bill that did not pass, we actually were able to get an amendment in there that would have exempted out small landlords from being subject to the just cause or good cause standards. So it does happen. Thankfully, the whole bill fell apart. But if it does move forward, we think that we will be able to get some exemptions and things in there. Let's see here. Pet deposits. Pet deposits. A deposit is a deposit. A deposit is a deposit. So yeah, we believe, what I have understood from the members of our legal department is that it is 1 month's rent, period, for all deposits. That a pet deposit is still a deposit. Do I think that someone might try to get cute and, charge a pet deposit? Probably. Don't let it be any of you though, please. So please don't let that be any of you. And I'm sure that we will hear a whole lot more about that moving forward, because there is a lot of pressure coming from tenant groups to allow pets, while at the same time kind of restricting the ability of landlords to accept them and to take the risk on accepting pets for what they may do. So for House Bill, let's circle back to House Bill 139, since they said that. So the notice requirement is existing, and that is for notifying your tenants of utility charges when those utilities are charged to the landlord, and then the tenant pays those to the landlord as well, when there isn't that direct relationship. So there is already a notification requirement that says, tenant, here are everything that I was charged. Here's how I came to determine how much of this overall utility bill that you owe me. And so that part has not really changed. It's really only if, you are providing gas and electricity service in addition to your water and sewer service. All right. Let's see here. Here is a good one about the governor's rental bill and the security deposits. You do not have to go back and invalidate any lease provisions that are already in. So for instance, if you're signing you signed a lease, in April, it had a 2-month deposit. You don't have to go back and either renegotiate the lease or, give them back 1 month when October 1 hits. That lease can continue until it expires, but any lease renewals or any conversions to like month-to-month tenancies after that has to be at a 1-month deposit. Okay, clearing through those. Let's see here. Preemption of Baltimore. We got to that. Here's a good one. Here's a really Oh, I love this question, Charles. Extra points, gold star for you. Why did they change the security deposit requirements? This can make it difficult for people who have compromised credit. Yes. Yes, that's exactly it. And that was exactly our argument to the General Assembly. Most of our members do not charge more than 1 month security deposit anyway. We heard that. We heard that from our property managers. No, I don't charge, 2 months rent unless maybe it's someone who, whose credit was iffy. Maybe it was someone, that was really borderline, just a little bit lower than what I might expect. But, if they paid this extra security deposit, I might take a chance on them. That's exactly what we said. But when you have tenant advocates saying, this is in the best interest of tenants, this has to change, this is preventing people from getting into rental housing, having to come up with 2 months rent and not just 1. That's a very difficult argument to overcome. And that was the situation that we found ourselves in with this particular bill. We do think that that's going to happen. We do think that people will be less likely to accept pets, to get back to that other issue. There are people who are on the margins who we think will be hurt by this. And it's just unfortunate. It's just unfortunate. So thank you for that question. I want you to come work on our advocacy team with us. Can the renter sell his or her rights to another person to purchase? No. No. So let's see here. In the case of an unsolicited offer, I trust the language is written such that the landlord can just say, no, they don't want to sell. That is correct. That is correct. The landlord can say, I'm not interested. In no way does it force a landlord to sell a property against their will. Other good part is that the tenant at any point during that 30 days can say, I don't want to buy. And when they say they don't want to buy and tell you that in writing, then you're done. Their rights are gone. Okay. So even more reason why, again, we want to do that pre-listing process and not wait until afterwards if we can. All right. House Bill 6. Does the landlord/owner have to list the property to the public at the same price or terms offered to the tenant or at the last counter offer? The landlord can list the property to the public at whatever amount they want to. But remember that 10%, that 10% delta, which gives that tenant a second bite at the apple. We've heard from our property owners that sometimes they will give the tenant a break on the price, right? Because they're already living there. It means they don't have to go in and paint and do the carpet, and they don't have to come get professional photos taken, and they don't have to do all of the things that they need to do to get the unit ready to market to the public. So sometimes they will offer the tenant a break on the price. Let's say the property is, worth $500,000. Tenant, I'm going to offer it to you at $480,000. Okay. If the tenant says no at $480,000, you can still go list the property at $500,000 or $525,000. You can list the property wherever you want to. Just remember that if you take an offer that is less than 10% of $480,000, the lowest amount that you and the tenant talked about, then the tenant can step back into the transaction. That's all you need to know. All right, we went through that one. Yes, the governor's bill has been signed. Again, doesn't go into effect until October 1 for that rental bill. Is it possible that there could be a legal challenge to it? always, there's a possibility that there could be a legal challenge to any law, any bill that is passed at any time. Always. But keep in mind, as we've talked about, DC has a tenant offered to purchase law. Baltimore has a tenant offer to purchase law. There are other places in the country that have tenant offer to purchase laws. So far, those have not been invalidated by the courts. We don't know what will happen to this or any other bill. I don't see something like this just on its face being unconstitutional. Doesn't mean we won't see lawsuits that come out of it, though. You know, it could be that you know, there is a landlord somewhere along the way that got harmed, you know, that maybe got less for their property than they intended to because of this. I don't know. That could make a case in the court. But as it stands, these laws are on the books elsewhere. All right. Will forms be created? Yes, we went through that. Let's see here. The money from the government repair fund, where does that come from? That gets to that reserve study bill that we talked about, House Bill 280. That is money that comes from the local government. It has to come from their tax revenues. It would have to come from their bonding authority. They would have to come up with the money to capitalize this fund, at least initially. And that is why, with this being a local option, we aren't sure how many local governments are actually going to take advantage of this. It's possible some could. We saw in Florida after the Sunrise condo collapse that Miami Beach did in fact set up one of these for those condo associations that had unmet capital needs. So could you know, I don't know, an Ocean City or some place like that decide, hey, you know what, this is a big enough issue that yes, we need to? Entirely possible, but just understand that there is nothing that makes a city or county do this. It is completely at their discretion. So if it is needed by, you know, the developments in a particular area, they're going to have to go to their county council or their city council or their county commissioners to convince them to implement this at the local level. All right, I'm going back through here, What else do we have? Krista, if you see one, jump in.
Sure. Going back to the pet deposit and so-called pet deposit question from earlier. I have, so are you saying the landlord that accepts a pet can't accept a pet deposit? Can they charge a non-refundable fee on rent? I.e. if rent is $2,000 per month, then if tenant has pet, it's $2,150 per month.
We believe that that is acceptable. A pet fee in terms of like an upfront one time, I think you're going to have a really hard time saying that that is not a deposit. I do fully expect a lot of folks to start implementing pet rent, and then next session, I fully expect a bill to be introduced on pet rent. You know, just such is the nature of these things. But you know, as we understand it, you know, having pets, you know, not being a protected class or not being a an area that you have to avoid for different treatment. You know, so far that is what has been indicated to us is that a pet rent, which is just the monthly increase in rent, is allowable. Let's see here. Can consumers, this is a really good one because it actually ties into a request that we have for you guys. Can consumers file a complaint with the state about condo resale packages? You can. There is a unit within the Attorney General's office that does handle condo and resale complaints. The remedy, though, is to go to mediation with the Condo and HOA Association. And that mediation may not take place for months after the transaction has concluded. So really, in terms of having an immediate, force and effect and getting, the fees, the allowable fees enforced, it's not a very good mechanism. What we would ask you to do, if you could, and believe me, if my email is overloaded with these, I will take it all day. If you are charged more than what is allowed, please send us a copy of that receipt or screenshot it for us. Because we will use those examples as evidence for the push in our bill this year and however many years it takes to get that bill through. We've been accused of, by some of the condo and HOA advocates of making up the stories that we have of these fees being charged in excess of state law. So the more that we can show them, no, we aren't making it up, this is actually widespread, the better. So please, I'm going to type my email here. Hopefully, I'm going to type my email in for everyone. All right. Send me emails, please, all day long. Please send them. All right. And we will get those stories in front of policymakers. All right. Thank you so much. In advance, thank you, because I know you guys have all of the receipts literally on that.
And along the lines of that same, topic, what is the allowed amount to be charged for HOA and condo documents?
Right. So the main packet fee, and we have a very good chart that our legal department put together, and we'll get that over to Kelly so that we can send that out to all of you who registered today. When the law was passed, current law was passed to put a cap on those fees, the packet was $250, the base packet, but that adjusts based upon the Consumer Price Index every 2 years. So right now, the fee for that main packet is $294 and some change. Okay. Then you have the inspection fee of $100 if they conduct an inspection. And then you have some expedited fees if the packet is delivered within 7 days or 14 days, and that's $150 at the discretion. We are aware that some associations say you can't order the packet in advance. You can't order the packet until you have a buyer name and a settlement date. And by the time you give us that, you have no choice but to pay an expedited fee. We are aware. We know that. But it really does put, the maximum allowable fee of just under, $500, assuming all of those conditions are met. And we've heard of some that are $700, $800, $1,200. So we know that those abuses exist out there. If you see anything like an account setup fee, a portal access fee, an additional processing fee, none of those things are expressly allowed in state law. So that's your first kind of sign that you're being nickeled and dimed on these.
Now, somebody had asked, what about having the seller file the claim with the Attorney General's office for the condo resale fees?
Yeah, it you absolutely can. And we encourage you to do that as well. Just understand that, I mean, this is the Attorney General, right? I mean, they're out there prosecuting, you know, corporate polluters and class action lawsuits and things like that. Unfortunately, additional fees on a condo and HOA resale packet are just not up at the top of the priority list, nor do they have the resources to track down all of these from each and every time that it happens. Yes, please, by all means, let the Attorney General's office know, because they, then they will at least see how often this does happen. But also, please, if you can, send those examples to us. Anyone here at Maryland Realtors, even if, Krista or Jackie or our legal department, whoever it is, just so that we have a critical mass of those to show to the General Assembly. All right, I'm going to keep going through, guys. Going to keep going through. New filing fees. Let's see here. I even have to reference this myself because there are a lot of different filing fees that go along with. And I don't know if we had shared the. Let me see if I can find those links really quickly for you, Donna, to our write-ups on those bills.
I can find those links for you, Lisa.
You sure? Okay. Yeah, if you have the one on House Bill 693 that has a breakdown of what all of the court fees are, but let's just go through those. The circuit court surcharge for civil cases goes from $55 to $85. District court summary ejectment goes from $8 to $43. And the district court tenant holding over breach of lease and other civil filings surcharge goes from $8 to $28 for those cases. So, and as we post the link to that summary, that is all in there. It is also on the advocacy page of our website of mdrealtor.org. All right. There we go. Excellent. All right. Still questions. All right, about the 10% lower offer. If the landlord isn't going to accept an offer, then no, you don't need to notify the tenant. Okay. This is if you accept an offer that is 10% less than what you were negotiating with the tenant, but ultimately walked away from. Let's see here. Effective date of the landlord tenant bill is October 1, as are most of the bills that pass in the General Assembly. Usually the exceptions to that are tax credit bills or things that run on, say, the state or local fiscal year. So October 1 is the date for virtually all of the legislation that we discussed today. Let's see here. We went over the security deposits. Let's see here. Security deposits reduced. Yes. Here's a very good one. There are exceptions to that landlord and tenant bill, and there are certain sales where this does not apply. So, for instance, Aaron asked a very good question about transferring a property from the landlord's name into an LLC that is wholly owned by the landlord. That is okay. That is okay. Disposing of a property through a foreclosure or an estate or something like that, that is exempted. If you are selling the property to a family member, that is exempted. Okay, so you will see on page 2 of the handout that there are a whole list of exemptions that are on the top of page 2. Okay, court-ordered transfers and settlements, fiduciaries. If you are selling or transferring the property to a government or nonprofit, the right of first refusal or right of first offer does not apply. Okay, excellent question. Thank you, Aaron. All right.
Can a rental applicant or tenant pay advance rent, i.e. 6 months rent in advance?
That's a good question. And I don't believe that that is, I don't believe that that is addressed in the bill at all. So I don't, assuming this is the, in relation to the governor's housing bill. I think that would have to be an agreement between the parties. It's a good question. It really, there is no change in the bill as it relates to that one. Okay, I have a couple questions about that. Lease renewals of existing. Yeah, Kevin, in terms of calculations of deposit, interest on deposit, I don't have that yet. That is certainly something that we can get some guidance on from our legal department, particularly as they are developing the forms to implement this. That sounds like a really excellent, like from the hotline question to go in a future edition of our magazine, or perhaps a webinar as this goes in. So excellent question. All right, someone who just paid $675 for a condo resale packet.
I'm just you got the links that I had posted to take you to these one pagers that Lisa was just referencing do not work. So I just posted the link to our advocacy page where both of them are identified, but we could always follow up with this to all of our attendees along with Lisa's email for you to share your condo HOA's fee stories.
Yes. When can we expect the pamphlet to come out about these bills? We have a write-up on it, just to cover 2 questions here, because I'm not sure which one this is. We have write-ups on our advocacy page on all of the bills that passed and a session summary. If you are referring to the bill, all of the bills that we discussed here today, that is already there and ready to go. If you are talking about the tenants' rights pamphlet, that the state needs to develop, they have until October 1 technically to do that. Typically we would see that, September, something like that. So that may be, that's kind of the one thing, because it is up to the state to develop that and not us. That is something we are kind of at the mercy of the state's timeline. For them to have that ready to go to include in the lease. So I hope one of the 2 of those answered your question about the pamphlet of bills. So there we go. Let's see here. A question from Hank about well water and testing. Very good and very timely question. There was a bill in 2023 that gets to well water testing, and particularly in rental properties, and then needing to disclose that The provisions of that bill do not go into effect until October 1 of this year. So last year bill, this year implementation date. Our legal department is aware of that bill. They will be developing or updating any of our forms to address that. So very good question, Hank. Thank you. All right. I'm hearing questions about, listing broker charging administration fees. These bills really are for fees charged by the condominium or homeowners association themselves. This does not get into any brokerage fees that are charged in the transaction of a condo or HOA property. So I just want to, make that clarification. These are what the condo or HOA associations or their management companies are charging for the resale packet itself, not other fees that are listed on the HUD one. So, so thank you for bringing that up.
So I see returning to House Bill 697, if a landlord has collected more than 1 month security deposit at lease initiation, do they need to return or refund the tenant any amount over the 1 month at lease renewal or extension? And if so, when?
It's a really good question, and I think it's one that we will get clarification on. What the bill has set forth is that you don't have to, if you're in the middle of an existing lease, once October 1 hits, you don't have to return the deposit on October 1, like on that date. You can let the lease process play out. But what we have talked about is when you get a new lease, that is when that limitation of 1 month's rent kicks in. And so I think that that is something that we can get some clarification on from our legal department and really talk about how to address that, to make sure that going forward you are in compliance, even though you were in compliance when the lease was signed and you were allowed to have 2 months. So yes, we will tell you what, we will get some clarification on that for you. I think that's a very excellent point as to exactly how that process needs to play out. So thank you.
And so if a tenant is in arrears and beginning the eviction process and the owner decides to sell in this time frame, is first right of refusal still required?
So I don't believe that the bill addresses this. That's my read of the bill, is that it did not address this situation. It did say that the tenant needs to be essentially a legal tenant. It needs to be someone who is expressly allowed under the lease to occupy the property. So it needs to be a valid leaseholder. That tenant cannot bring in someone who is not a valid leaseholder to exercise that right of first refusal. I don't see anything in the bill. Of course, I'm going to go back and read it with a fine-tooth comb after we get off here. But I don't see anything in the bill that really addresses that exact situation, that you're essentially pursuing an active court eviction case against a tenant while contemplating selling the property. Like while it is still pending. It's a very good question. All right, our condo bills for all condos are just residential. It is for residential. That is typically the area upon which we engage for condo and HOA, because that is where the limitations on resale packet fees and those areas reside within the code.
How does active military pertain to the transaction fee we have to waive for military VA buyers based on the loan?
So that gets into the mortgage financing part of this. Essentially, what this gets into is the provision of housing itself. So for instance, this should not apply to VA loan conditions at all. And I have a feeling that that's why certain things were amended out of this bill. This really applies to, I cannot refuse to rent my unit to someone because they are a member of, active duty military or reserves. I cannot say that the rent I'm going to charge them is 3 times more than what I would charge someone who is not an active duty member of the military. I cannot tell an active duty member of the military that the unit is not available and tell a non-member of the military that it is available. So it really is in the provision of housing itself, the housing, not necessarily the terms and conditions of the loan. However, we do have, of course, we have source of income as a protected class as well, which does get into, where you say, you can't say, I refuse to consider VA loans, right? So we kind of have both of them in that instance. All right, I think we're getting down here. I think we are getting down here. Let's see here. All right, we went over brokerage fees. Please respond about cooperative commission as to whether it applies to commercial transactions as well as to residential transactions. And I'm assuming this is on our buyer brokerage bill, Krista? Is that how you're reading this?
I am assuming.
Okay. So assuming that this is about our buyer brokerage bill, this is about the exclusive right to represent agreements and the exclusive listing agreements, which are residential in nature. If you are still on the call, Robert, and that is not the question that you asked, please feel free to hop back in. We'll hang out here for just a little bit, just to make sure that we got everyone's questions answered. All right, you guys have been real troopers hanging with us for an hour and 45 minutes here. I really appreciate it. We're gonna just stay here in case anyone has any last minute questions. And let's see here, we did have some of our advocacy resources put into the webinar chat that leads you directly to those documents that we were referencing. The governor's housing bill, the governor's renters' rights and stabilization act, one that we spent a lot of time on here today. And then in addition, our session summary that gets into that. All right. I am not seeing any additional open questions here. Going once, guys, going twice. All right. Well, thank you all so much for being with us. We really appreciate the time that you have spent with us. You gave us some very, very good questions. Thank you. We will put together more information on these and other bills as October 1 approaches. Of course, again, please be sure to check out our new legal legislative update class that has been revamped new this year to include many of the bills that you see here, the many changes that are taking place in real estate in Maryland. So Krista, any parting words, anything that I forgot?
Well, I mean, I can always remind everybody, as we always do, that committee application window is open at this moment. And just as, you know, we rely on your stories to further our advocacy efforts, we rely on your participation in our committees to keep things running smoothly. So please apply to our committee.
Wonderful reminder. And if this stuff that we've presented to you here today, if that excites you, if you want to be more involved, we do have, as I mentioned, our legislative committee that goes through these bills each and every week of the General Assembly session. We have an issues mobilization committee that reviews campaigns that our local associations are undertaking in terms of advocacy and engaging the broader community in policy issues affecting real estate. And we also have a public policy committee comprised mostly of brokers, but also of some practitioners who help guide those bills that are going to become our realtor priority issues each and every session. So if you want to be involved, we welcome you with open arms. So thank you. Get out there and sell some real estate. And we really do appreciate your time and engagement as members of Maryland Realtors. Thank you so much.